You all know ICJ Kenya's legacy in safeguarding constitutionalism and the judicial independence. So that what the session we're now going to have next is of persons who have stood firm in their journeys and have been awarded Jurists of the Year variously. The persons we're having today as panelists, we start off with the 1999 Jurist of the Year recipient, Honorable Martha Karua. Honorable Martha Karua is a senior counsel. She's the party leader of the People's Liberation Party. She's a firm believer and a protector of the rule of law. Our current position is that Kenya deserves leadership that serves all people, not just the privileged few. Our movement is about restoring integrity, justice, and inclusive development, where economic growth uplifts all, governance is transparent, and opportunities shared. Because true democracy, prosperity, and progress belongs to all of us. She's a renowned politician, human rights advocate, and has got a distinguished career in legal practice. She has been a politician, she has been a minister, and as I said, a strong defender of human rights. Her contribution in that sector led to her being awarded the 1999 Jurist of the Year Award. Our second panelist is Commissioner Emeritus Lawrence Mute. He's an accomplished human rights lawyer, practitioner with over 26 years of experience at subnational, national, and international levels. He has extensive expertise in human rights research. He has served in various commissions. He has been a special rapporteur of the freedom of expression and access to justice, access to information in Africa, chairperson of the Committee of Prevention of Torture in Africa. He also serves and holds and served in various boards in governmental, intergovernmental, and civil society organizations, including Open Society Foundation, Human Rights Initiative, Article 19, Kituo cha Sheria, Uhai, the East African Sexual Health and Rights Initiative. He has received several honors, and we're pleased to have him today as one of the rapporteurs. He is Jurist of the Year awardee of the 2012. The third panelist, Commissioner Emeritus Jedida Wakoyo Warui. She is the Chief Executive Officer of Witness Protection Agency, an advocate with over 25 years experience in human rights. She holds a Bachelor's of Law degree and Master's of Law degrees. She has been a Commissioner of Kenya National Human Rights Commission. She has championed the protection of vulnerable and marginalized groups, especially when you're dealing with intersex and other situations where persons are facing challenges. She is instrumental in advancing penal policy and judicial reforms with a focus on aid, refugees, and the paralegal approach, and intersex rights. She has served as the chairperson of Intersex Persons Implementation Committee under the Office of the Attorney General. She was honored to be the Jurist of the Year awardee of 2020. Our fourth panelist will be with us online, and she has a pre-recorded clip. Faith Moni Odhiambo, who is currently the first president of the Law Society of Kenya. She has previously served as a council member of the Law Society and the board secretary of FIDA Kenya, as well as the representative of the Nairobi branch of the Law Society of Kenya. She's a distinguished advocate a partner in private practice. She lectures at the University of Nairobi, and you all know her participation in the defending both the Gen Z demonstrations and other victims of state extrajudicial killings and extremism and other disappearances that happened in the year 2024-25. She'll be presenting her pre-recorded clip, which will be shared. Faith has been recognized for excellence and leadership, has received various awards, and she's currently reigning as the current recipient of the Jurists of the Year Award 2024. Now, before we start the panel, a kind reminder that in the year 2025, we lost a very distinguished jurist, a person who supported ICJ Kenya for many years, and a person to whom most of us are indebted in learning the law. I want us to take a moment to remember and recognize Feroz Noroji, Senior Counsel. Thank you, Ms. Ida. As jurists, you understand that the award recognizes exemplary courage and contribution to justice that you have presented to us. It honors personal sacrifice, professional excellence, and unwavering ethical commitment. It showcases role models for the legal profession and the society. The theme for our discussion today, which you are going to lead us, is we want you to assist us and guide us in understanding each of you in various ways. You have lived through defining moments in Kenya's legal and political history. We kindly request that you share with us your experiences that have shaped your understanding and the resilience that you have endured through that process in shaping and fighting for justice for Kenyans.
Today mirrors yesterday. We are living through times that are reminiscent of the 90s, when as a young lawyer, I became active in matters of governance, firstly, just as a lawyer within the Law Society, thereafter as an elected member of the council. We were out there representing what we called unpopular, in quotes, clients that were being politically hounded by the police. And because lawyers representing those clients also became hounded, we learned the art of solidarity to protect ourselves. So we would call each other and appear in court as a group of lawyers, 20, 30, sometimes even 40, even signing statements to insulate ourselves. We would sign statements, circulate them not just in Nairobi, but in various points within the country, get them brought back to Nairobi and release them, that there's a group of lawyers, saying this and that. Those were days that we consider dark days. But lo and behold, today we have got a great constitution. The same thing is happening. And the impunity levels, in my view, are higher than the dark days. That a person can be shot in the streets at point blank range for no reason than being out there hawking, for no reason but being a protester. People can be removed from their houses and shot to death, shot in the head, in the chest, and, in areas like the stomach where they know you will bleed to death. So what I'm seeing is worse than what I saw in the 90s. I don't remember during the Moi era a day that hundreds were killed, except, of course, the Wagala massacre, which was not in the public eye. We came to know of it later. Are as good as people who man them. We have seen some specks of hope in the judiciary because the matters taken to it, especially by the Law Society and by other organizations, have helped us to push back. But we are not winning in all the cases. Inordinate delay in matters of habeas corpus, which are matters of life and death, that we have cases pending filed a year ago, is an indictment on the same judiciary. So a few officers doing the right thing, others behaving like nothing is happening. And I keep asking myself, if so much can be done by the little who stand up, what about if all of us, you in your space, did your bit? The result would be completely different. We would be able to stop the impunity. It's not just about those who are in power. It's about those of us in the various institutions, various places, refusing to take responsibility. We need solidarity internally. We need solidarity in the sub-region and in the region. In East Africa, what I have seen is a coordinated effort, especially by the 3 original members of EAC, and that is Kenya, Uganda, Tanzania. The standing together of authoritarian leadership to oppress the citizens. And we say we too as citizens have to push back. So we also are mobilizing together to push back. Yes, we were stopped from going to observe in Tanzania. For your information, I had already been there and observed once on April 24th. But because we held a press conference outside the court, calling out the Tanzanian government, our second mission on the 18th of May, we were deported. A few of us had already entered, and you all remember how Boniface Mwangi of Kenya and Agatha Atuhaire of Uganda were mistreated and tortured in Tanzania when the whole world knew they were being held there, when Kenyan authorities knew Boniface Mwangi, a Kenyan national, was in detention, when the Ugandan authorities knew their national Agatha Atuhaire was in detention. This is the clearest signal that our regimes were cooperating in doing the wrong thing. To date, we have Bob Jagi, Nicholas Oyo, who disappeared in Tanzania, in Uganda 36 days ago. The Ugandan government denies or is silent. The army swore an affidavit in court they are not having them. But then, President Museveni is the head of all the security agencies, in the sense they have a security committee, national security committee, just like Kenya. Therefore, if it's not the army, they would know who else. If it's not the security agencies, they are paid to know exactly what they're supposed to do. Whatever institution you are in, you could be in the police force, in the criminal justice system, you could be a prosecutor, you could be in the electoral system as an electoral commissioner or a chair like my brother here, Isaac was. You could be a judge. Are you doing enough? Are you informed by your own insecurities? Are you trying to be government more than government and forgetting that you work for the people? We need to call out those who are doing wrong, and we need solidarity with one another. I am so pleased that I'm sitting here today when SADC has revised their original statement, issued a bold statement indicating there were no elections in Tanzania. What is the way forward? And I salute South Africa as the big brother in SADC for its leadership. South Africa led the world to condemn the genocide in Gaza. South Africa can still lead Africa in standing for democracy, human rights, and the rule of law. So we are telling South Africa, and especially their president, Cyril Ramaphosa, we recognize their moral force in Africa. We would want them as members of SADC to do more so that the elections or sham elections in Tanzania are nullified. And people come to the table, do the necessary reforms, Tundu Lissu is released, and everybody else incarcerated and disappeared, accounted for, and then they can hold free and fair elections. Why do we hold ourselves to such low standards? I believe that the compromise in Kenya in 2007, without revealing what had gone wrong, because we ought to have opened the ballots. That's what I was insisting as a negotiator. Form the coalition government, yes, but let's have an audit, because we still have the ballots, so that we know exactly what happened. But that decision of burying things under the carpet, a bad example to Africa, it was spread to Zimbabwe. I do not know where else it will be spread to. Brothers and sisters, we've got to stand up, give ourselves higher standards, and let's not look so much to the West. They have also abandoned democracy. They are putting ahead of everything else exploitation of our resources under the guise of trade. So they will prop up a dictator, an authoritarian ruler who opens the door for exploitation. They'll also meddle with the elections. And I'll not go too much with that statement, because this is supposed to be a very short statement. So we are on our own. We better stand up for what is right. I want to thank you. And before I release, let me just say, you said a politician who was. I'm a politician who is, and who is running for president. What is happening is that the middle class, which is yourselves and me, think politics is dirty, it's not for them. Yet some of them will follow politicians for favors. You know very well politics regulates the environment you work in. I didn't start as a politician, I started as a lawyer with a private practice. But when I saw the conditions that were there, that the regime was encroaching on the law society and swearing that they will affiliate it, we started resisting as young lawyers. We realized that politics regulates everything, including the services you get. That's how I got called to politics. We don't all have to be politicians, but you can determine whom you elect. You can resist and call out government. But trying to partner with a regime whose DNA is completely not going to change, and they have shown it, may not help. So what if we all resisted? I always ask myself, 25th of June 2024, what if we had come out, all of us, on 26th of June and said the killing of our children yesterday was totally unacceptable? That is what Nepal did. That is what Bangladesh did. People power. They shot people in Bangladesh until those shooting, the army, said no more. The madam had to leave herself. In Tanzania, it is said at some point the army was telling the police they cannot go on shooting. What if people continued coming out? What if the Tanzanians today said, we didn't elect you? This is something we have to ask. We cannot hope that the system will correct itself. It will not. It's you and me. It's time for you to become that opposition, offering your ideas on how the political parties can work. You are also the people who will bring accountability to political parties. Don't expect me to tell my colleagues who are my competitors that I'm better than them, because they'll also tell me in turn they are better than me as leaders. It's you who can give us the tests, the questions. If we answer satisfactorily, you say this is the leadership we want. Start from your ward. Don't wait to elect the president. Start from your ward. Concentrate on all the 6 seats. That's how we can prepare the next and a better leadership. And let us as civil society, teaming up with people, including politicians of goodwill, come up with a governance standard that we must all follow. Come up with the transformation agenda that we want. This we must do together, not individually, and because I do not intend to miss the flight, I'm going to Uganda tomorrow morning.
Okay, thank you, Martha, and I'll be quick. And congratulations for the work you're doing within the continent, showing that human rights have no borders. So what I wanted to ask is actually about Kizza Besigye and his case. I understand that he's becoming senile, and I fear personally that he might die in prison. And I wanted to know, is there a chance of you pushing for this case now to go to East Africa and the Africa Court of Appeal? Because Uganda, they may just let him die. Is there a way to overpass and just try the case outside and see, and also call upon exactly what you said, call upon the East Africa and the Africans who are in the Africa Court of Appeal or Court of Justice to actually act on behalf of him in Uganda?
The court cannot act unless moved. We have filed cases about his abduction in the East African court, in the Kenyan courts, and also we have reported violations of his rights by the Ugandan government, by the courts, with the African Commission. We are calling on the sub-region and regional bodies and asking them, what is the worst case scenario if you spoke truth to power? It's losing your job. You can go back to your home. We don't have to cling to jobs or be overly polite. You can be firm, but speak truth to power. That is the task we are telling the African Commission. It can do what SADC has done in their revised statement, because there was an earlier statement by Mutharika, which was sort of sanitizing. The statement of yesterday or the day before is beautiful. Let us say the truth as it is, irrespective of whom it hurts. So for Besigye, may I tell you, he at times gets frail when he is sick. His spirit is so strong. He's not going to die anytime soon unless if they kill him. And because they do not intend, they don't look like they'll release him before the elections, we'll keep going. I know tomorrow there is not much we'll do in court, but we want to show them we will never get tired of pushing back. So I'll be there to do my duty alongside Ugandan lawyers.
So that I contextualize my questions, because I have more questions for us to answer after my two seniors have spoken. One is by David McCullough, an American historian, who said, "History is who we are and why we are the way we are." And then Albert Green Hubbard, an American philosopher and an artist, said that he who does not understand your silence will probably not understand your words. When I look back at my history, significantly my history was shaped in the 90s, as senior counsel has spoken. And when I reflect back, actually, I must have been a Gen Z then, because I was younger and they were more senior. And it was about the political agitation. I remember two significant ones: the release of political prisoners. I remember the Freedom Corner. I also remember no budget without reforms, no elections without reforms, all that agitation. I do recall when I served at the released political prisoners, there was a very good engagement between jurists and those who we called them human rights defenders. Today we are calling them paralegals. I say this specifically because as jurists, as lawyers, there's something we have lost. We have lost the respect, we have lost the goodwill, we have lost the public trust of the people. And many people do not believe as lawyers, as jurists, will promote the rule of law, will respect the same rule of law, and guide the people. So I do remember significantly when it came to issues of release political prisoners, I do remember going to Naivasha Maximum Prison, where we were agitating for the release of the last political prisoner under the 1982 coup, who was James Apinyi Adhiambo. And while there, which was a very difficult access for a lawyer, the officer in charge of that prison said, why are you wasting time with him instead of focusing on someone who is actually more vulnerable? And who was he referring to? He gave me the name and later we followed through. That was Kisilu Mtua, the man who was convicted for having killed Hello? Yes. So why am I giving this? Is because then the galvanizing was with institutions, non-state actors, galvanized together with special interest groups. When I look back and I look now, what is the difference? Thank you. What is the difference and what can we learn from the past and the present? Then the non-state actors were very strong, worked together as non-state actors together with the interest groups. Today, the people have become much more powerful, which is a good thing in terms of their sovereign power, and are working less with non-state actors. Why is that? We need to ask that question and see how we can galvanize that momentum. When you look back then, the non-state actors were not many. There were very few. Today we have more non-state actors. The populations are high. We worked with less numbers. Today, the numbers are being put together by the publics. Today, we have very strong human rights institutions. We have a very enabling constitution. If you look at the Kenyan situation, our problem is not want of legislation. Our problem is implementing that which is on paper. If you look around the continent, Kenya is leading in terms of many things. When it comes to legislation, we are ahead. If you look at the practice of the law, we are possibly ahead. But are we where we need to be? No. How do we, as Kenyans, as jurists, work with what we have? I hear statements that institutions are under siege. No, it is not institutions that are under siege, as we call them. It is the individuals who have a structural issue as they sit there. It is individuals who are fearful of doing what is the right thing. So how can we move forward as a jurist, and how do we reflect on this? Some of the questions I'll ask is, what is the role of the judiciary in terms of reaffirming and asserting the rule of law? The judiciary, I have looked at some of the good precedents that we have as a country. You realize that when the environment is politically charged, we do not have good jurisprudence that enables that political situation. We hardly save the day, it is more we sway the day. And you can look at some of the cases that are there. But we have opportunities as jurists to make jurisprudential gains when the environment is more quieter. Like now, we have an opportunity to interrogate our jurisprudence around issues of elections and develop both political strategies and legal strategies in court to ensure that we have a difference. We have a challenge in terms of celebrating what we have and using those we can celebrate with. As I was reflecting on this, I was asking, how many women can we speak of who have moved this country in terms of economic and political justice? Can we name them? Can we name them? What have they done? And I'm happy to see now within the civil society the opportunity to recall our colonial history and rephrase what our history is in terms of people who have done great. We need to be able to recognize, to celebrate, and document their contribution so that the younger generations can learn. I started off speaking about lawyers, jurists, and paralegals. I think the paralegal movement in this country is an opportunity that jurists need to work with, because those who are paralegals of human rights defenders today, or the proverbial activists, have an opportunity to work with us in a simple, practical way of moving forward. Lastly, I want to ask another question in terms of institutions. You've realized that as we go into the election process, we'll be working more with the judiciary. And it is easy for us to work with the judiciary. Why? What about the legislature? What is difficult about working with the legislature? And the legislature is the institutions that legislate for this country. Why is it difficult for us to work with the executive? What do we need to do? Because the legislature and the executive, if we are able to re-engage with them in a much more robust way, will help us in terms of ensuring that we are able to implement the gains that we have for years. And we're also going to be able to build into that resilience. My last issue is, if you look at the course of history, before the 90s, very few people who had worked in non-state institutions were serving in government. Today, they are quite a number. How do we utilize them? How do we identify and work with them to ensure that they become the internal catalyst to help in terms of changing the system? Because if we do not do that, it's going to become harder and more difficult for us. But we have an opportunity. This morning, the chairperson of IPOA was speaking, and he spoke about the issues of security and policing. How do we work with an institution like IPOA that is the only civilian oversight on issues policing? How do we engage the National Police Service, the EACC, and the DPP in a much more deliberate way as jurists, so that we can ensure that they begin and they do serve the interests of Wanjiku? And lastly, I want to speak of where I sit at the Witness Protection Agency. It is an institution that assists to support institutions like EACC, non-state actors, IPOA, among others, in terms of securing witnesses. And you know there's no trial without a witness. How do we ensure that those kind of institutions are enabled to work much more effectively and efficiently, especially now during this electoral process? How do we ensure that the lessons learned in Kenya are replicated in Africa, and we are able to support our sister or brother states across the region? As we speak right now, there are 3 bills that are coming to Parliament very soon that we need to watch and look at. One is the Anti-Corruption Amendment Bill. The other is the Whistleblower Bill. And the Anti-Corruption Bill reinforces the issue of whistleblower for purposes of witness protection and strengthen the EACC, the Anti-Corruption Commission. And the last one is the National Victims and Protection Service Bill. Why am I speaking to these 3? Because it's going to become increasingly important for us to see how we can begin moving, protecting whistleblowers, and ensuring that compensation is actually a legitimate process and also a legal process that can be able to help us deal with the brutality and the losses that we have incurred in the past and also now. So as jurists, my plea to you is we look at these bills and ensure that institutions that are being strengthened, because that is EACC, the Victim Protection Board, the Commission on Administration Justice, and the Witness Protection Agency are able to be enabled to deliver on justice within the country. Thank you.
Recently, I think we were discussing on this table a week ago, the constitutional, not even the Constitutional Court, the Employment and Labor Relations Court made a pronouncement. In fact, in record time, Ogada, if I'm wrong, you will correct me, in record time had a petition in less than 30 days and issued a judgment on a matter that touched on a constitutional commission. I am making a reference to understand why there is a need to strengthen our institutions. In that particular judgment, the Employment and Labor Relations Court cut an axe on the mandate, the constitutional mandate of the National Police Service Commission, and transferred it to the IG. Remember, when the IG also sits as a commissioner in the National Police Service Commission. Why am I saying it's a moment for reflection and indeed to reinvent ingenious ways of constitutional protection? Is that what is good for a goose is good for a gander. If it can happen to the National Police Service Commission, it can happen to any other constitutional body, including very, very important bodies like the one you sit on. Importantly, a point that I would want to make an emphasis on is the role of the Independent Policing Oversight Authority. We have devised mechanisms in how we take up police accountability, especially on excesses on the police. One of these methods, and I would be asking many of those who are in this room to think about it in their key projects, on making police accountable, not on compensation by Treasury or any other executive institution, but on their own budget. Now, this is important because when they feel the pinch coming from their own pocket, in fact, they will see the need for policy change. I am saying this because I know it will be awkward to talk about the compensation panel, which I will avoid altogether. Faith Odhiambo, the president was sitting there, but now she has left. It is important to make an underscoring as we live here on methods of partnerships that will enable us to strengthen institutions. I know the next place where they will be going to is in the judiciary. If they have not managed successfully, and I'm happy that Dr. Deche is here today, if you attended the Diani conference and had a presentation in her paper on judicial insulation, you'll understand where I'm coming from. I highly support, even on a personal level, but the Law Society will be eager to see how we can partner to strengthen our institutions, especially those that are constitutionally mandated to enforce and implement human rights. That is all for me.
Thank you for those questions, Deputy President, on the issue of the need, why the need for institutional strengthening and the opportunities for partnership. I think when you look at after the promulgation of the 2010 Constitution, we had two opportunities in terms of interpreting the Constitution appropriately, in terms of implementation, when it was challenged in terms of the institutions or role and functions, or in terms of human rights protection. So we have judgments that speak appropriately to the constitutions, and there's a lot of departure. Then if you look at the statutes that were implemented, then they were negotiated political instruments. For example, if you look at the instruments of the Kenya National Commission on Human Rights, NGEC, the Gender Commission, and the CAJ, or Ombudsman. 3, it was supposed to be one big commission, and then also maybe have an ombudsman. But that was not the case. And even the question of the merger of Kenya National Commission on Human Rights and the NGEC is still a political question out there. So there was bad drafting, or there was political negotiation. And then there were also deliberate omissions. If you look at the issue of whistleblower as an example, there is no adequate protective mechanisms despite the international commitments that we have made. And so, a number of whistleblowers today are not able to be properly safeguarded under the EACC or under the Ombudsman CAJ. And therefore, there is need for us to enact certain legislation, but also to support interagency collaboration in those institutions. If you look at the Victim Protection Board, the Act, it is very poorly drafted because it was a private members' bill. So I can go on and on. So there is that need to strengthen, but also more importantly, you can have very good institutions, but how are we capacitating them? Who is being appointed and or who is submitting themselves for those institutions? The second issue on partnership, there are very many opportunities for partnership. And there are many state institutions that have signed even memorandum of understanding across. One area of partnership is the area of public interest litigation. State institutions hardly will file a public, I'm yet to see one. But through that collaboration, opportunities will emerge for identifying public interest matters. And I want to really appreciate ICJ, because if you look at the compensation, post-election violence compensation claim, the issue of the CAS, those are opportunities that ICJ went forward on and has had good judgment that has helped in terms of governance and matters compensation. The other area is policy reform. The voice of the non-state, the voice of the public is very important in terms of agitating and assisting proper policy position in terms of the legislation that comes. And that's why the law society, if you look at the law society, it is in almost many or all significant recruitments and boards of various institutions for a reason. The last one that I would bring to is the issue of the budget making process. No state institution will tell you that they have enough resources, whether financial or non-financial. What is our budget policy? The famous the budget policy that is presented every year before the budget is read and everything. What does it say? How many of us as a non-state look at that budget policy statement? What does it speak into in terms of the government priorities vis-a-vis what you as a non-state appreciate? I think that's another area to work with government institutions on the same. Thank you.
Let's speak about the African Union. I would say that its best times were its first decade. So you're looking at the period from 2000 to around 2010, during which time you had significant normative standards being established, whether it was the Maputo Protocol. And so then that's a context within which Africa adopted the African Charter on democracy, elections, and governance. Now, obviously, there is a distinction between establishing a normative standard and actual implementation, because remember, you're then speaking about the technique of the law, the requirements, but then unfortunately, and in fact it's not even unfortunate because it's a reality of life we have to keep in mind, then there are the politics and there are political considerations. So for me, where did the rain begin beating us? Look at the number of unconstitutional changes of government which have happened in Africa. And where did that primarily begin? Because at some point, Africa, the AU actually put its foot down. So if you recall, Mohamed Morsi. So whatever you thought about Mohamed Morsi, he was actually elected democratically to become the president of Egypt. And so then what the army and associates did, which then meant that Mohamed Morsi was no longer president, effectively was an unconstitutional coup. And initially the AU did actually agree with that. But then realpolitik comes into play. And for me, the past 6 or 7 years have been significant. Remember, we've had so many unconstitutional coups. One of the most problematic for me was when Junior Deby took over from Senior Deby, when Senior Deby was killed in Chad. And the moment that the African Union did not call that as an unconstitutional coup, then in a sense we were losing it, we had lost it. And so yes, we can speak about the law, we can speak about APRM, we can speak about all those things, but the question then becomes, how do we mediate between the law and its requirements and then the politics? And that's a challenge. So even as jurists, if we simply focus on the law and do not try to figure how the politics, how the realpolitik play into that scenario, I think we are not going to be helping our people. Now, a couple of other things I should say. Of course, so think about the African Commission on Human People's Rights, which I was a member for a while, or even the African Court on Human and People's Rights. Of course, a senior counsel said you have to move these bodies. But remember again, also you're speaking about 2 tracks. So there is a very specific legal track. You file a communication before the African Commission on Human People's Rights, a case. But you see, for you to file a case, for example, you have to have, exhausted local remedies. There's a whole procedure around that. And so if you've not, then clearly you can't get a hearing before the commission. But at the same time, and that's why the confusion comes in, the commission then also has a mandate which is not specifically, technically the legal mandate. So you can make appeals on the commission, and the commission can issue statements, can do, protection missions, and that sort of thing. And I think that's where possibly the commission could always do better. Of course, as the leader is saying, the commission does speak about limited resources, etc., etc. So my challenge to all of us is that first and foremost, we need to understand the detail of these devices. And there are different devices which you can pull out. There are different tools you can use, for different purposes. And in all honesty, one of the big problems is the time it takes for things to be done. So even if you're going to be hard, sometimes it take 1 year, 2 years, 3 years, 4 years. It will take a very long time. But you see now, those are our realities. The question then is, what are we still able to do, even despite those realities? Thank you.
And so mine was just to say that we have to watch the upcoming amendments to the oversight institutions laws, including yours, including IPOA, including the National Police Service Commission Act and the National Police Service Act. So I thought that to maybe just sound an alarm that please be on the lookout. When it comes for public participation, we need to have the jurists' input on this. Thank you. And it's not to enhance the powers of those institutions. More often than not, it is to cut their wings, to put them into a particular straitjacket. And so mine was just to say that we have to watch the upcoming amendments to the oversight institutions laws, including yours, including IPOA, including the National Police Service Commission Act and the National Police Service Act. So I thought that to maybe just sound an alarm that please be on the lookout. When it comes for public participation, we need to have the jurists' input on this. Thank you.
Thank you, Chairman. Any other intervention, comment? You can take it, then we take it.
Thank you. I would like to appreciate my mentors sitting before us, Commissioners Wote and Jadida and Honorable Manga, who just left. When we reflect to the history of critical moments when jurists have been called to stand up, we're looking at the post-Moi pre-Moi, multipartism, post-Moi, independent institutions beginning to be built, the National Commission on Human Rights, etc. Then you have the 2010 Constitution, and we have a whole raft of activities and a lot to do with implementation of the Constitution. And now we're at another juncture with economic justice questions and Gen Z protests. If you were to hold a crystal ball and look to the future, are there opportunities that we are missing or gaps? Are we mentoring enough? Do we have a sufficient army? And I've heard since morning, as the keynote speakers were speaking, and you've also reiterated it in this panel, that democracy is anchored in our social values, that there's a lot more that's going on outside and beyond the text of the law. What are we missing as jurists? Are there certain interventions or actions that we need to be doing? The versatility we were talking about earlier. But more so, I worry, and maybe I worry from where I sit. I don't know what it looks like from where you sit. Are there more jurists coming after us to take on the baton and continue with this race that we have said is a continuum for decades to come? Thank you.
I'll take the next question from Waiko.
Thanks. Jadida, you challenged or you asked a question relating to the transition between people who come from non-state actors and join government, and why are we not exploiting those opportunities so that we can get them to help with the entrenchment of the rule of law, because they're in strategic places. And I find actually this to be fundamental, because I've always thought that this was always a good pathway into helping entrench rule of law in a country like Kenya or in other countries which have at least a chance at entrenchment of the rule of law. But I find the trend to be the same. You have a new government, and I'll give the example of the current government. There are quite a number of people who went into this government from civil society. Within the first 3-5 months, you could engage with them. And in fact, they were trying to take up, or they would try to take up the agenda. And this is true even with the former government of Uhuru Kenyatta. To a large extent, it's true. It was true with the 2002 Kibaki's government. But I don't know what happened to people from this sector after some time. I don't know whether it's power that gets into them, or the trappings of power, or the privileges of power, or it's paranoia, or it's dissonance, that they feel they're the ones who need to act more government than government. And so it becomes very, very difficult to engage with them. That's the reality for me. It may not be the reality for others. Before I retired as a litigator, I actually, I would file cases. And sometimes I would go as far as the Attorney General and say, let's negotiate this case. Because I believe the state will lose as the case is framed. But I actually don't think the consequences of just losing in a judgment are the best outcome for the state. A negotiated settlement is better for the law and the state. We've never been taken up on that. We've never been taken up. I've done it with at least 2 attorney generals. I've done it with state councils. We've never been taken up. The compensation panel. There is an easy way to do this constitutionally. And there's a way that for example, the cases that are in court, if the state really was interested and was genuine about this, to go and say the executive will lobby Parliament to put in resources, and also to lobby Parliament to put in the regulatory mechanism. Let the responsible institutions like Kenya National Commission on Human Rights be the driver of this. But no, this is a political, it's something that has to be done from a political point of view. And people who are driving this are people who've been in the rule of law sector. Professor Makau Mutua is not strange to this. So I don't know. And we were invited this morning to be calling out people, and I think it's important for us to be calling out people. And it's important for us to call out ourselves. And actually, justice, and I want to end with this, Mr. Morgan. You know, Justice Kanchale said a really fundamental thing this morning. And I think it's the point, for me, I would invite all of us to reflect about as we go, as we deal with this conflict. Whether we believe, the values we say, we believe in values that we profess, or we just say that we believe in those values to earn a living. And we are a privileged lot, we can do a lot, and I think when we have opportunities, and all of us have opportunities, whether in government or in informal spaces, we have to be true to power. Thank you.
Christine, the question I ask myself, thinking about the future, is how much of Kenya's history, so you see it's counterintuitive, so it's about the future, but actually it's about history, so it's about history and it's about the future. How much of Kenya's history is on TikTok? So all these young people who grow up and become the next generation of lawyers, how much do they know about the Mwakenya trials? How much do they know about Dedan Kimathi? Actually, even just in terms of the languages which they express or seek these ideas. And I mean, it's a failure on our generations, including ourselves, including myself. You know, what language do they use? Where is this information? So for me, we should all be concerned that the younger generations actually understand where we came from. You know, you look at the last couple of years, and there will be younger people, there will be possibly even older people who will not recall that the kinds of things which are happening now are the sorts of things which happened in the 1980s, okay? So for me, that is a great concern. But then, again, ironically, I'm thinking that in Kenya we seem to be stuck in this time warp. So there's no way we can not link the fact that our political leaderships have stayed at the same level for all these many decades. It's essentially the same people. Essentially the same people. So even then, as we think about the future as jurists, we should also be thinking, because I said that linkage between the politics and the law. You know, intergenerational changes, yes, but also it's about the leadership. So for me, we need to keep these thoughts in mind as we move forward. But prospecting forward, in 10 years, I am one of those who thinks that we can, every 5 or 6 years, keep telling Kenyans that all we need to do is change the constitution. I don't think that's good enough. I think in 10 years' time, we need to have reached a point where we are actually able to work within our systems to make the politics work, Because if the politics work, then I think we have a strong Bill of Rights, we have strong arrangements which can actually enable us, as a country to be on a trajectory of prosperity. But, those are some of my thoughts. Thank you. I should say that, it was an honor being made a jurist of ICJ those many years ago. And I think it's an excellent thing that these conversations should continue happening every year. And so I appreciate the fact that I was invited to be on this panel.
It is true, when amendments go to Parliament for oversight institutions, there's a clawback. It is true. And it is true, we must remain vigilant. Indeed, during the keynote address, part of one of the issues was vigilance, and through the price of liberty is eternal vigilance. So we must be vigilant. One of the issues that came in the opening remarks is about dignity and opportunities are concepts of justice. And so for me, is to, when we reflect back and what can we do, the crystal ball. Commissioner has just spoken about the Gen Z. If we look at this room, how many of us are Gen Zs? Now, not in the past, now. We have a serious challenge, and that is a challenge that we are facing in the law society of Kenya, because the older of us have been outnumbered, and we are unable to work and deal with the energy of the Gen Z. So we must put the Gen Z on the front line. Let them take the leadership. Because we did then. We did then. Why do we have a challenge now? And the challenge we have is because they are more in terms of numbers than us. I still do remember those conversations, for those who remember when we were at forces, the younger Gen Zs were listening to the older, but the numbers were few. Now they have outnumbered us. If they are their CEOs at 30, then they must take the leadership and go there. Then I want to add to a comment he has made about history and the use of digital technology. A lot of this conversation, including this one, it will not be properly digitalized and broken down in simple English to those who are the best consumers of this information, because we are converted as we sit here. So we need to think about TikTok, we need to think about Instagram, and all that AI stories. Today, in YouTube, there are so many AI stories about the history, and there's a lot of deliberate of the West African stories. What are our East African stories? What are our Kenyan stories? What are our Southern stories in terms of the liberation and the work in these countries and continent from a human rights perspective? So there's a lot. Two, the training of lawyers has not changed. I don't think it has changed. Maybe words like trial advocacy, but the substance to link with what is the legal issues today and the future we propose are not there. And I can give a very simple example. You have a whole statute on witness protection. Where is it taught in the law of evidence, jurisprudence, trial advocacy? How do you litigate in a case where there's a protected witness? All those are gaps, and we continue to litigate. So we have to train our young lawyers differently, and they will be able then to provide the leadership that we want. The government question, and it is true, and for me we need to remember my first quotations about our history and the silence. People do not change. They do not change. And allow me to use your case, Waikwa, because I think the first encounter is when we were at release political prisoners. Am I right? And the issue, you are a student activist then, and my sister, who is a lawyer without papers, my senior, and Jerika Beberi, who for many years I thought she was a lawyer until I realized she knew good substantive law and how to engage with the legal mechanism. better than lawyers. Now, when people go to government, they don't change who they were. Even when they are trapped with those powers, you need to ask yourself, what is missing in your conversation? How do you engage them? And I say this because I remember listening many years to those who were in detention. And one of the things they would say, if it wasn't for the prison officer who told me, do not touch, do not, I'm bringing you the food, do not eat the food. That is how they survived detention. During the times of released political prisoners, when prisoners, when arbitrary arrest was happening and people were in police station, it was ordinary quiet police officers who would tell you, ako Pangani, ama ako Central, or wherever they are. So how do you work with those who are in government in a different way from the way you were working with them when they were in non-state? They do not change. If you understood them when they were in non-state, they are still the same. It's just the way they are operating within a government framework, within a political establishment. So for me, the opportunity is there, and we must seize it and work with it now. There is still an opportunity. Allow me to stop there and say, and lastly, to say that there's a strategy we also must have as jurists. When decisions are made, when judgments are concluded and signed, what happens to that judgment? What is the implementation strategy of that judgment? It was only the other day, as an example I had, now people are being trained, the judiciary is being trained on the case of the 160 girls. When was that case? Quite a while ago. If you look at the security amendment decision, how have we internalized that decision? Because it continues to haunt us as we proceed. So what is our post-judgment implementation strategy as jurists? Is that the case law that we emphasize when we are teaching? I'm not a teacher. Maybe Dr. Commissioner Deche would speak to that. For me, lastly, is to say, and to ask ourselves in terms of the crystal ball, we have Kenya National Commission on Human Rights. It is the only watchdog on human rights per se, let me put it principally. I know we have challenges with it, but how are we working with it and what is our relationship with it? We must shift that relationship. Because you're not happy with it, other people are not happy with it. You know, the culture of impunity. We must change that relationship and make that institution formidable. IPOA, it is the only civilian policing oversight authority. Again, our relationship with it and how we work. We must shift. We must make it work for us. We have no option. And lastly, the Witness Protection Agency, it is the only safety and security institution when it comes to witnesses who are vulnerable and intimidated and victims. Again, what is our relationship with it? How do we rephrase that? So because we must, those three institutions as a minimum must work for us, and they must be able to uphold the rule of law. They must work with us in terms of the administration of justice. I thank you.